Hello and welcome to our third and final presentation about the Renters' Rights Bill. And today we're going to be discussing ending a tenancy. So we've already covered off starting a tenancy, managing your tenancy, and then this is the final presentation which you're going to talk about ending a tenancy, so how you and your tenants can finalise a tenancy under the new rules after the 1st of May. So we're going to look today at, first of all, how can tenants give notice, so what happens if a tenant wants to leave, and then how you as a landlord can give notice to your tenants. So in case you're not already aware, on the 1st of May, Section 21 will no longer exist. If you want to use a Section 21, it must be served by 30th of April. Now, that means served by 30th of April, so ideally you don't want to be doing it any time after the 28th, because in case you're not aware, the date of service is normally at least 24 hours after. Even if you deliver it by hand, it's normally deemed as served 24 hours later. So really 28th of April is the last day you want to be sending any Section 21s out. After the 1st of May, you will only be able to ask a tenant to leave under Section 8. So first of all, let's look at how the tenants give notice. So any one of your tenants can end the tenancy at any time by serving 2 months' notice in writing. So after the 1st of May, fixed periods in contracts will no longer exist, and a tenant can give 2 months' notice at any point in time after they've moved into the property. Now, under the Act, the terms of in writing have actually changed, so it can now include email, WhatsApp and text. So it's any form of writing, doesn't have to be in the post or any formal written communication. It can be via email, WhatsApp or text. Now, the notice must end on a rent due date. So if the rent due date is the 15th of the month, then they would have to serve notice on, say, the 13th of January if they wanted to leave on the 15th of March. So what that means is technically, when your tenant moves into a property, it is effectively 3 months' notice. The earliest they can leave is 3 months after the tenancy start date, because they can't give notice on the day they move in, or if they do, it's deemed as served the following day. So therefore, because it's due to finish on a rent payment date, it would effectively be 3 months in is the earliest date a tenant can leave. Now, you can agree an earlier date if you want to. So if the tenant says, look, I've missed the deadline, but I want to leave on this date, if you and the tenant both agree in writing, then absolutely you can agree a shorter date. But those are the dates you can hold the tenant to, 2 months based on the rent payment date. Now, the tenant can also withdraw, but only if you and other tenants agree. So in the event you've got a couple who rent a house from you, a husband and wife, for example, the husband can give notice for both parties, and then he can withdraw, but only if you and the other tenants agree to that. Now, the notice period of 2 months is what's called mandatory information, so you need to make sure when you sign a tenancy agreement with the tenant that that information is in the tenancy. So they need to be told in writing up front of what their notice period is, and the normal way to do that is in the tenancy agreement, and that must be in there before it's formalised and signed and executed. Obviously, as standard, all of our agreements will include the notice period, but if you are doing any of your own, you need to make sure that's included. So what to do when your tenants give notice? Well, first of all, check that it's valid. Make sure they've given you the correct dates. If there's other tenants in the property, you will need to inform them that one tenant has given notice and what date that tenancy will end. They will then either need to agree to leave as well, or they will need to sign a new tenancy. So if, for example, you do have a husband and wife who are renting a property from you, and husband that decides he's moving out gives notice, wife decides she wants to stay, then you will need to create a new tenancy agreement on the date the husband leaves and that tenancy ends. Otherwise, all parties need to leave, and then you can remarket the property and form a new tenancy with a new tenant. You can, at this point, renegotiate new terms and rents with existing tenants. So if, for example, some of the tenants wanted to stay, you can sign a new tenancy and you can agree a new rent. It doesn't come under the rent review legislation. So even if the tenancy is less than a year old, if one party wants to leave and you're going to be forming a new tenancy, then you can create a new rent and agree new terms. If they don't leave on the date set, so again, so you've got two parties involved, one decides they're leaving, the other one says, no, I'm not going, then you will need to evict them if you want them to leave. If you can't agree a new tenancy, or you don't want that person to stay on their own, so for example, Let's use husband and wife example again. Wife decides she wants to move out. Husband says, no, I'm not leaving. But he doesn't meet affordability on his own. You don't want to sign a single tenancy with that person. Then you will need to evict them if he decides not to leave on the date they've given notice for. So you need to do that via an N5 or an N119. And you'll need a solicitor to do that for you. So if you want your tenants to leave, so we're looking at landlords serving notice now. As I've said, after the 1st of May, you will need to serve what's called a Section 8 notice in the prescribed format. So Section 8 is a legal document, and it has a very prescribed format that you will need to adhere to. You can find them on the government website. And the difference between Section 8 and Section 21 is under Section 8, you're always giving the tenants a reason that you want to end the tenancy. So that could be that you want to sell the house, it might be there in rent arrears, but you must include a reason, and on the Section 8 notice that reason must be included. Now, depending on the reason that you're giving that you want the tenant to leave will depend on how much notice you need to give them. So you need to make sure on the Section 8 you give the correct required notice, and again it ends on the correct day. Under the Act, councils have got lots of new powers now to fine landlords if you use the wrong form, if you try and end the tenancy verbally, if you try and evict somebody illegally, or if you use grounds that you don't have a reasonable chance of success with. So for example, if you are trying to evict somebody for rent arrears and they're only 4 weeks in arrears, well, under the new Section 8, tenants have got to be at least 3 months in arrears. So if you serve a notice when they're only 4 weeks, you wouldn't have any chance of success with that in the court. So again, they could go to the council, and the council could potentially fine you up to £30,000 for what is technically an illegal eviction. Now, with Section 8, it's also key that your deposit is registered either in a scheme or you've given the money back to the tenant. It can be registered late, so if you haven't registered it and you've forgotten, you can still register it and it can be registered late. But if you get to court and the deposit has not been registered in a scheme, or you haven't given it back to the tenant, it'll be thrown out straight away. So it's really important to make sure all your deposits are up to date if you're dealing with them yourself. Now, there are certain grounds under Section 8 that you need to inform the tenancy of beforehand. So none of these will really affect the majority of landlords, particularly if you're dealing with normal day-to-day tenants. Any of these that do need to be relied on will be included in our tenancy agreement as standard, but you might want to make sure that moving forward, if you deal with, for example, student tenants and you want to rely on certain grounds, that they're in your tenancy agreement at the point it's signed, otherwise you won't be able to use them as a reason to serve a Section 8 on a later date. Now, given that Section 8 is a lot more complicated, the document is a lot more convoluted, it's very technical. If you put the wrong word in the wrong place, it can be thrown out of court straight away. It is essential that you use a solicitor to serve a Section 8 moving forward. If you have a rent protection policy, this is normally included in the cost and it's included in their service, but Infinite Property won't be serving Section 8s after the 1st of May. We'll be advising landlords to use a solicitor. You can, of course, do it yourself. You don't have to use a solicitor. However, our advice would be to get a solicitor to serve notice. The reality is a lot of these notices will end up in court, so it makes sense for the solicitor who served the notice to then represent you, and they've got a paper trail all the way through from start to finish. So with Section 8, you have two different types of grounds. You have what's called a mandatory ground, which is grounds 1 to 8, or discretionary grounds, which are 9 to 17. And the difference between the two is on a discretionary ground, the judge has complete discretion over whether or not to issue a possession order. With the mandatory ground, the judge doesn't have discretion. If you meet the requirements and you provide the necessary evidence, the judge has to give you possession. Whereas with discretionary, the judge has complete discretion over whether or not to issue it, regardless of the evidence presented. There's a couple of standard ones that are used fairly commonly. So rent arrears comes under grounds 8, 10 and 11. If you want to sell the property, that's ground 1A. And then you've got some others that you might come across, but fairly rarely. Antisocial behaviour is 1. Then you've got things like breach of contract and tenant deliberately deteriorating the property, which may become more common given that Section 21 is now being removed and there's no mechanism really to just ask a tenant to leave if they're not particularly the best tenant. You may find things like breach of contract and deterioration of the property get used more commonly because you'll need to give a reason to ask a tenant to leave. So if we look at the most common ones that landlords are going to use, so first of all, if you want to sell your property, if you want to move in, you can serve a Section 8 notice, and you will need to give the tenants 4 months notice. Now, what you can't do though, unfortunately, is you can't ask for possession within the first 12 months of signing a tenancy. So basically after the 7th month, you can give them 4 months notice to end in month 12, but you can't ask for them to leave the property before the first anniversary of signing the tenancy, or moving in, sorry, should I say, not signing, moving in. Now, once they've left the property, you will then be restricted from reletting the property or marketing it for let for 12 months after that notice ends. So, tenant leaves the property, you must, well, actually you don't have to make a move to sell the property, but you won't be able to relet it or market it to relet for 12 months. So the property would have to be empty, basically. That would include Airbnb, short-term lets, any form of marketing the property for let. Now, you can relet it to a family member if you've asked them to move out from which you're selling. You can relet to a family, but it must be their main residence, so you can't sublet it after that. So you can't rent the house to your brother who then sublets it to another party. It must be their main residence if a family member moves in. If for some reason during that 4 months notice period you change your mind and decide you're not going to sell the property, then you'll need to reissue the notice with different grounds if you still want the tenant to leave. And if you do end up going to court because the tenant hasn't left after the 4 months notice, ideally you would attend yourself to confirm that you want to sell or move into the property, because that is the only evidence really that you can provide to a judge to show that that is the reason you want the tenant to leave. So the second most common reason you'd ask a tenant to leave is because they're in rent arrears. So ground 8, which is the main ground you will use for rent arrears, so serious rent arrears, is a mandatory ground. So currently, you're entitled to ask for possession unless the tenant can bring the arrears under the 2-month threshold. So at the moment, under ground 8, a tenant only has to be 2 months in arrears, and you can serve them 14 days notice or 2 weeks to vacate the property. If they don't leave after that 14 days, you can then apply to the court for possession. From the 1st of May, that is being extended. So the 2-week notice will become 4 weeks. So you need to give them 1 month's notice. And also the tenant will need to be 3 months in arrears rather than 2 before you can serve that notice. Okay. Now, if they're in arrears due to any universal credit delays, they will not be counted by the court as arrears. So you won't be able to go to court on the basis that they're in arrears if they're trying to claim universal credit and there's a delay in their claim. If they're receiving universal credit and not paying the rent to you, that's different. That is still arrears, and absolutely you can apply for possession. But if there's a delay in their claim and they can provide evidence from universal credit there's a delay, then the judge will not accept that as rent arrears. So with that in mind, if you do have tenants who are claiming universal credit, it's really important you stay in touch with them when they move in. If there's going to be universal credit delays, it would generally be at the start of the tenancy, because that's when the tenant's making their application. Occasionally, tenants will apply mid-tenancy. So, for example, if someone lost their job after they've been in the property for, say, 2 years, they might need to make a universal credit claim. But it's really important you stay in touch with your tenants to find out what's happening, but also more important to make sure they're doing everything they need to do to get forms back, etc., provide any evidence to universal credit so that there's no delays in those payments. If your tenant is 2 months in arrears and they're claiming universal credit, you can apply for direct payment. Universal credit will then notify you if there's an issue with their claim, and that's why it's not being paid. So it's really important to stay in touch for that reason as well, to make sure that if the arrears get substantial, you can ask universal credit to pay you directly. What's more important as well is, obviously, if you do have to go to court, you're going to need to provide evidence that you've tried to negotiate any rent payments, if you've made any payment plans that haven't been adhered to. So it's really important that most of this is done in writing, ideally. If you do have a phone call with a tenant about this, you need to follow it up with an email, WhatsApp message, etc. Try not to deal with rent arrears purely via phone call, unless, like with us, your calls are recorded and you can provide that evidence. But if you just speak to a tenant directly, it's really important you follow it up in writing, just so there's a record that you can provide to the court to show everything that you've done so far. Hopefully that's fairly straightforward. If you have any questions at all, feel free to email us on the email address on the screen, info@infinitepropertyltd.com. Put RRB in the subject and one of my colleagues will come back to you as soon as possible with the answers to your questions.